Good morning, everyone. I'm Doug Robinson. I am the chair of the Employee Benefits section of the State Bar of Georgia. Welcome to our seminar today. We have two excellent speakers for you today on important topics in the area of employee benefits. Our first speaker is Lisa Gomez. Lisa's a former Assistant Secretary for the Employee Benefits Security for the Department of Labor. She has since that time worked for 30 years in private practice and is currently the founding member of LMG Collaborative Consulting Services. Our second speaker is Elaine Yap. Elaine is an associate attorney at Nelson Mullins in Atlanta, representing private companies in employee benefits and executive compensation matters. I have the only other announcement I have before I turn it over to our speakers is that your 2 hours of CLE credit is automatic if you complete the seminar, so you don't have to do anything. And with that, I'm pleased to turn it over to Lisa Gomez.
Thanks so much, Doug, and good morning. I couldn't remember if it's morning or afternoon where we are, but good morning, everyone. Really happy to be here. And I am going to start off today's discussion with a review of the federal mental health parity rules that apply to both ERISA governed plans as well as private insurance plans that recently came out in September of last year. So I'm just going to share my screen. One moment. Okay, hopefully everyone can see that. And I'll go through this presentation, and as I'm going through, please feel free to put your questions into the chat. I'll do my best to monitor the chat as I'm talking, and at worst, if I'm not able to multitask in that way, I'll turn to the questions at the end of the presentation for sure. Okay, so just to start off, let's just make sure I can work this. Hold on. All right. Okay, so yeah, a little bit just quickly about myself, following up on Doug's introduction. I had the privilege of serving as the Assistant Secretary of the Employee Benefits Security Administration within the United States Department of Labor during the Biden administration. So I was there from October of 2022 through January 20th of this year. And in that role, one of the things that I had the, again, privilege of being able to lead the agency on was working together with the Departments of Health and Human Services and the Department of Treasury on both the proposed rules implementing the Mental Health Parity and Addiction Equity Act, as well as the final rules implementing MHPAEA. And in conjunction with working on those rules, the tri-agencies, Labor, Treasury, and Health and Human Services also worked on a fact sheet and a report to Congress that discussed the implementation and enforcement of the final of MHPAEA, the law itself and the regulations. So I'll reference the laws and the regulations as well as the report to Congress during this presentation, and you can find all of those materials on the Department of Labor Employee Benefits Security Administration's website, which is www.dol.gov/EBSA for Employee Benefits Security Administration. And I also, just before I get into the presentation, want to say that having left the Employee Benefits Security Administration, I I want to just take the opportunity to really recognize, acknowledge, and thank the staff employees of EBSA who are, incredibly dedicated folks and hardworking folks, including but not limited to the wonderful people who work right in Georgia in the Atlanta regional office of EBSA, and to many of whom work on the task force, the MHPAEA task force for EBSA, working on this rule, and really wish that we could have folks from EBSA presenting, current employees of EBSA, presenting for you today, because they are really the ones that are in the weeds. But unfortunately, just with transitions, we don't have folks available to do these presentations. So I will do my best, having been there, but wanted to just take a moment to recognize those really great employees. Okay, so we'll start out with an overview of where the law was prior to the final rules that were issued in September of 2024. So just to start out with what mental health parity requires, the mental health parity law as a federal law has been around for many, many years, dating back to 1996 and going through different iterations in the time since then. And mental health parity at its base just requires that I say just not to make it sound simple, but just to get out the basics of mental health parity. The law requires that plans, health plans that offer mental health and substance use disorder benefits cannot offer those benefits in a manner that is more restrictive or creates greater barriers than benefits for medical and surgical benefits. MHPAEA does not require health plans to cover mental health and substance use disorder benefits. Although I want to just be clear that when we're talking about these laws, we're talking about federal laws. So under federal law, there is no requirement that plans cover mental health and substance use disorder benefits. However, if a plan does cover those benefits have to be covered in accordance with the mental health parity rules. MHPAEA does require that, as I stated, any plan that covers mental health and substance use disorder benefits do so, in a way that's not more restrictive than medical and surgical benefits. And in evaluating whether the requirements of MHPAEA are met, we look at both quantitative and non-quantitative treatment limitations, and we'll get into that in a little bit in this presentation. So when we are doing a comparison of mental health and substance use disorder benefits to medical and surgical benefits, there are 6 different, we'll refer to them as buckets of benefits, 6 different categories of benefits that are looked at in order to determine whether or not the benefits within each of these buckets are being offered in a manner that that complies with the parity rules. And so those 6 buckets are inpatient in-network benefits, outpatient in-network benefits, emergency services, inpatient non-network benefits, outpatient non-network benefits, and prescription drug benefits. And so the first thing that we look at as to whether or not benefits are being offered in a way that is no more restrictive is looking at the quantitative treatment limits. And we're talking about quantitative treatment limits. These are limitations that are based more on pure numbers. For example, financial requirements. So deductibles, co-payments, co-insurance, out-of-pocket maximums are the deductibles that apply to medical and surgical benefits on par with the deductibles that apply to mental health and substance use disorder benefits. Co-payments. Does a person have to pay a higher co-payment to see a mental health specialist than than they have to pay to see a medical specialist? For example, seeing a psychiatrist versus seeing an orthopedist, for example. So those are the types of financial requirements that we're looking at under quantitative treatment limitations. And then in addition, we're looking at, again, numbers related to numbers of visits that are covered, days that are covered, days in a waiting period that a person has to wait before coverage will kick in. And these types of requirements can't apply in a manner that is no more restrictive than the predominant financial requirements or quantitative treatment limitations that apply to substantially all of the medical benefits, medical and surgical benefits in that same bucket. And these are the types of limitations that I think many more plans and plan administrators have found to be somewhat easier to measure because it's much easier to look at whether or not a plan is charging the same co-payment or is charging or is limiting the number of days for for mental health and substance use disorder care in a way that's more restrictive than medical and surgical care. For example, on its face, it's much easier to be able to detect in a plan that if you say that a person needs to that a plan will allow up to 120 days in an inpatient facility, a hospital, or some other inpatient facility for, let's say, someone who has had a stroke or someone who is undergoing cancer treatments. And but a plan says that if you are being treated inpatient for a mental health condition or for a substance use disorder, and that's limited to 30 days versus the 120 days, then that's just an on its face more of a restriction and not allowed. So in looking at these quantitative treatment limits, we look at these two steps. First, with the substantially all requirement, whether a quantitative treatment limitation applies to 2/3 of the medical and surgical benefits in any specific benefit bucket, and then the predominant level. So it's more than or more than 50% of the limit of the medical and surgical benefits that are in a specific bucket. uh, is more than that, being imposed on the mental health and substance use disorder benefits in that same bucket of benefits. Where we were seeing more of an issue because plans, as I said, were used to and adjusting to the quantitative treatment limitations. And that's not really where both as practitioners, plans were having issues in trying to comply with the requirements, but also from a regulatory standpoint, the regulators were seeing less and less of an issue with the quantitative treatment limitations. Where there were issues were with what we call the non-quantitative treatment limitations. And non-quantitative treatment limitations are limitations on coverage or access to care that are things that are not these straight number types of tests. So what is a non-quantitative treatment limitation? They are treatment limitations such as pre-authorization requirements. So what does a person need to do in order to obtain pre-authorization for for mental health care or for substance use disorder care as compared to for medical care? Do they even need to get pre-authorization for similar type of medical care as they do if they are seeking mental health care. What does network access look like? Are there as many or a similar amount of providers who are in the network for treatment of mental health care or substance use disorder as there are for treatment of medical and surgical conditions? So is it what does it look like to try to access an in-network provider for if you have bipolar disorder as compared to finding a network provider if you have a medical condition? But what does that look like? What are the referral requirements like? For example, do you need to get a referral to see before you can see someone for a substance use disorder condition or for an eating disorder as compared to a medical condition? What does the formulary look like? So this is the list of preferred drugs that a health plan will pay for. What does the formulary look like when we're looking at drugs for medications for mental health and substance use disorders as compared to medical conditions? Provider reimbursement rates. When we are considering what does the plan reimburse a mental health provider for an office visit as compared to a medical provider for an office visit? How do those reimbursement rates compare and how are they different? Medical necessity criteria. So what criteria is applied for to obtain coverage for, again, a mental health condition as compared to a similar medical condition, and those types of things. And so under MHPAEA, a group health plan cannot impose non-quantitative treatment limitations that are more restrictive when applied to mental health and substance use disorder benefits than when applied to medical and surgical benefits in that same bucket. The non-quantitative treatment limitations really came within the spotlight under the Consolidated Appropriations Act of 2021. And the Consolidated Appropriations Act of 2021 was passed at the end of 2020 and became effective in February of 2021. I think one thing to note is that as we're talking about we'll talk a little bit at the end about where we expect things may go going forward, particularly since we are in a new federal administration under a new president, new leadership. So in thinking about where things might go, it's important to note that the Consolidated Appropriations Act was enacted in 2020, so during the last Trump administration, and was implemented during the Biden administration. So it will be interesting to see how the new Trump administration approaches mental health parity. But in talking about the Consolidated Appropriations Act, there were certain requirements that applied to mental health parity specifically under that act. Number one, the Consolidated Appropriations Act required that all group health plans starting as of February 10th of 2021 conduct non-quantitative treatment limitation analyses, comparative analyses, or CAs, we would refer to them as, to compare the benefits that were provided by those health plans for mental health and substance use disorders as compared to medical and surgical conditions. The results of those comparative analyses can be requested both by the United States Department of Labor or by participants in the health plans. If a violation is found, then by the Department of Labor, then a plan has 45 days to correct that violation or they can be subject to certain consequences. Number one, the plan needs to notify all participants in the plan that the plan is not in compliance with MHPAEA. The Department of Labor is required to publish a report of plans who are not in compliance with MHPAEA, as well as notify state regulators of that determination. And there is a potential for both statutory penalties to apply and a requirement that the plan reprocess claims so that they are paid in a manner that is compliant with MHPAEA. I will say that this is what MHPAEA and the Consolidated Appropriations Act requires. But in order for those various consequences to be triggered, the Department of Labor needs to make a final determination of noncompliance. And even though we're talking about a 45-day time frame, in actuality, in operation, there is a long period of time, or at least, during the last administration, there was a long period of time that a plan would work with, I should say that the Department of Labor would work with a plan to try to get to a point that that there was a correction of any violations. And so there were very, very few plans that actually obtained a final determination of noncompliance from the Department of Labor, and where any of these various public notices, public shaming of plans, where it got to that point, because the department was very much more focused on correcting problems rather than naming plans that had, that were not initially found to be in compliance. So some of the latest updates that came out of the final rules that were issued in September of 2024, and I'll go through these changes, but I also want to just state that the initial the proposed regulations were issued by the Department of Labor, HHS, and Treasury in the summer of 2023. And as with all proposed regulations, the regulations were issued in a notes and comment procedure. And under that procedure, the tri-agencies issued and published these proposed regulations. There was a comment period during which anyone within the public, stakeholders, individuals, congressional stakeholders, anyone was invited to and did, in fact, submit comments on the proposed rules. We at the Department of Labor and with the tri-agencies conducted meetings with interested parties, received tens of thousands of comments, and took a very long time to both consider those comments, review and consider the input that was received from the various stakeholders, which went from advocates for mental health and substance use disorder patients and providers, plan administrators, both insured plans, self-insured plans, employer-sponsored plans, people across the country with very different perspectives and great input that was received. And a lot of time was taken by the tri-agencies to consider that feedback and to incorporate it into the final regulations, which again were issued in September of 2024. Under the final regulations, there was a new two-part test for non-quantitative treatment limitations that was developed and included in the final rules. So under the final rules, group health plans are required to review the non-quantitative treatment limitations and look at, number one, how are the limitations designed and applied, and number two, what types of outcomes, looking specifically at data, what are the outcomes of the non-quantitative treatment limitations? And in developing this part of the rule, I can tell you that something that was very important to the tri-agencies was not just looking at what the rules, what a plan's limitations looked like on paper, not just what the words of the limitations were or how they, what they said, but also the outcomes, how they worked in practice. Because what we found, and so much of these final rules, both the proposed rules and the final rules, were based upon the experience of the tri-agencies in enforcing the mental health parity rules over the years, what they had seen in practice, and what the tri-agencies felt was needed in order to really effectuate mental health parity for individuals who were seeking mental health care. And so one thing that was really important was looking at, again, the outcomes, and not only what these rules look like on paper, but how they worked in operation. And were they really working, was mental health parity and the enforcement of mental health parity really working to effectively get to the goal of not having these more restrictive benefits. So that's a little bit of just background on what the tri-agencies were attempting to achieve through the final rules. There was, in the proposed rule, a more mathematical test that was proposed to try to get at having parity with respect to NQTLs. We received a lot of comments from the industry on the non-workability of the mathematical test that we had proposed. And so in the final rule, we did not include that mathematical test, so I won't get into it here. But we looked at more of a, how could plans, without really just getting down to crunching numbers and doing calculations, evaluate whether or not NQTLs were more restrictive. And I think that, that approach, while we all thought, and the industry definitely was persuasive that the mathematical test was not the way to go, it does lead to a result of having a more subjective review of NQTLs, which, I think people can say can work in different ways. Everyone is very much looking for ease in trying to apply the mental health parity rules, but and is also looking for flexibility, and sometimes that can work in both ways of giving people more flexibility, but sometimes perhaps not giving 100% clarity on whether or not NQTLs are being applied in a correct or incorrect fashion. So I think that there's two ways to look at that, and some people may argue as to what is best or not. But in looking at the design and application of an NQTL, so how an NQTL is written and also how it's applied under the rules, the plan needs to look at the processes that are applied to NQTLs, for example, prior authorization requirements, again, the referral requirements, different plan standards that might apply to different types of treatments, and how the NQTLs are administered. A plan also needs to look at what standards of care are applied to mental health and substance use disorder benefits, what types of guidelines are used, and what rationales are applied to determining whether or not a claim will be payable. And so that is the first part of the final rule. Plans also need to be looking at evidentiary standards. So what information, sources, evidence does the plan have to back up the standards that apply to the review of claims, looking at what information a plan might have from its third-party administrator, from its insurance carrier, to determine whether or not the NQTL is being properly applied, and also looking at what discriminatory factors may be coming into play. For example, what types of looking at the outcomes of applying certain factors and whether or not they appear to be in in operation discriminatory, what types of licensing and accreditation requirements are applied, and also whether or not plans are properly looking at certain factors coming from the perspective of whether or not there is fraud that is trying to be avoided in the plan. So those types of requirements are in effect for plan years on and after January 1 of 2025. The second part of this is a three-step process looking at the data, and again, looking at these outcomes of the NQTLs and how they apply. So looking at outcomes data under the final rules, there's no exhaustive list of what type of data needs to be looked at. We tried to give some examples, some parameters that plans could incorporate in doing their review. Some things that plans can be looking at, should be looking at, are the number and percentage of claims denied when you're looking at mental health and substance use disorder claims as compared to medical and surgical claims, what your turnaround times look for pre-authorization requests. Is it taking a longer time to get back to someone who is seeking mental health care as compared to medical care? What the network utilization rates look like for mental health and substance use disorder care as compared to medical and surgical care. So does it seem that people are in seeking mental health care using out-of-network providers at a much higher rate than or at a higher rate than they're using in-network providers for mental health, for medical care? And those types of numbers will also clue into whether or not we really have parity there as between the two types of benefits, and also provider reimbursement rates. So looking at plans, contracts with providers, contracts with facilities, what they're actually reimbursing providers and facilities for mental health and substance use disorder treatment as compared to medical and surgical treatment. In comparing the outcomes, looking at the medical and surgical conclusions in the outcomes for medical and surgical treatment in the same bucket as mental health and substance use disorder treatment, to see whether or not there are material differences in the outcomes. So again, for example, looking at provider reimbursement rates for in-network outpatient treatment as compared to mental health and substance use disorder inpatient, in-network outpatient treatment as compared to medical and surgical inpatient in-network outpatient treatment, to look at what the provider reimbursement rates look like and what the network utilization rates look like, and not requiring that there be equal numbers there, but looking for material differences. And we did not specifically define what a material difference would be. There's not a specific number there, but it is something that, I think that plans should be looking at and should be prepared to, if there is a difference in outcomes there, be prepared to be able to explain why that is. If there are material differences, then plans are not expected to make changes overnight, and instead they are required to take reasonable steps to address those differences. In coming up with the final rules, I think the tri-agencies were understanding that things cannot be corrected immediately. At least not everything can be corrected immediately, but there needs to be some types of reasonable steps being taken by the health plan to address these material differences. For example, plans to uh, raise reimbursement rates for mental health and substance use disorder providers, plans to educate, or steps being taken to educate participants on how they can obtain care and how to obtain care from an in-network provider, as compared to an out-of-network provider. Educating participants on how to go through the pre-authorization process, and just trying to improve results. Offering different types of care settings for mental health and substance use disorder care in order to achieve better results. For example, telehealth. Many people may find that it is much easier for them, for a number of reasons, to obtain care through a mental health provider through telehealth than it is to obtain care through a medical provider. So looking at those types of things, and also how to review your credentialing process so that you can have so that a plan can have more mental health and substance use disorder providers available in network than maybe they currently have. And that requirement is effective for plan years starting on and after January 1 of 2026. And we had, the agencies had intended to be able to issue more guidance on these various requirements. There is some concern, I think, just because of delays in obtaining political leadership within the agencies with the change of administration, as to whether or not there will be more guidance forthcoming. I do think that it is very important for the regulated community to, where more guidance is needed, to make those needs known to the various agencies, and so that we can, because I know that there were several things that were being worked on before the end of the administration, before, I certainly left, and I don't know where those various projects stand at this point. But it's an area where certainly getting the word out that these are things that need to be worked on is something that's important, and not to assume that they may be, being worked on. Some new requirements under the new regulations, this meaningful benefit requirement, which requires that if there is coverage for any mental health or substance use disorder, um, in it for any mental health and substance use disorder benefits in any of the various buckets that I referred to, there have to be meaningful benefits for mental health and substance use disorder in any bucket where you're also providing medical and surgical benefits. And we discussed that in the final rule to mean that there has to be at least some type of benefit for a core treatment for a mental health and substance use disorder condition in every classification for which a medical and surgical core treatment is covered. And some of the terminologies, we tried our best to provide examples of what was meant for each of these requirements in the final regulations. And so, these, hopefully those examples will be helpful. And I do know that the folks at the tri-agencies are very willing to work with plans who might have questions about the application of any of these requirements. In some other new requirements in the final rules, there was a definition of mental health and substance use disorder as compared to medical and surgical in the final rules. There are disclosure requirements included in the final rules that the NQTL analysis must be disclosed upon request. So that was implementing the requirement of the Consolidated Appropriations Act. And also, in implementing through the final rules the requirements of the Consolidated Appropriations Act. The final rule includes 6 items that need to be included in the comparative analysis that a plan does under MHPAEA. The comparative analysis needs to include a description of the non-quantitative treatment analysis, the non-quantitative treatment limitation, the identification of the factors and evidentiary standards that were used to design or apply the NQTL, a description of how the factors are used in the design or application of the NQTL, a demonstration of the comparability and stringency of the NQTL as written, as well as a demonstration of the comparability and stringency in operation of the NQTL and what findings and conclusions the plan has discovered through the comparative analysis. And again, these were not really new requirements. It was more just implementing the requirements of the Consolidated Appropriations Act. Another new requirement in the final regulations is the fiduciary certification. This is a requirement that applies only to plans that are governed by ERISA, so only by employer-sponsored plans or jointly administered multi-employer plans. Those types of plans need to provide a certification that the fiduciaries of the plan engaged in a prudent process to select a qualified service provider to perform and document the NQTL comparative analysis, and that they are monitoring that service provider. There was no model language provided within the model rule, excuse me, within the final regulation on what needs to be in the fiduciary certification, but we tried to just outline what we would be looking for. And specifically, the final rules changed from the proposed rules with respect to this requirement, because the proposed rules were worded in a way that required the fiduciary to much more on their own be certifying that the requirements of MHPAEA were being complied with, as compared to what came in the final rule, which is more that the fiduciary has engaged in a process, a prudent process to select a qualified service provider that would be doing that analysis for the fiduciary, as opposed to the fiduciary knowing this, on their own. So that was another, a form of accommodation that came out of the final rules. If a plan does not comply with the requirements of MHPAEA, the agency may prohibit the plan from imposing a non-quantitative treatment limitation that does not comply with MHPAEA if the agency issues a final determination that that NQTL is non-compliant. And a plan will then need to demonstrate that it is in compliance or correct the violation, for example, by reprocessing claims that were improperly applied or that were improperly processed based on a provision that or an NQTL that violated the law. Plans, if there is a final determination, the plan is required of noncompliance, the plan needs to provide a notice of noncompliance to participants, and there is model language included in the final rules on what that notice needs to look like. The final notice of noncompliance is included in the report to Congress that the tri-agencies issue each year, and there were only 4 plans that got to that final notice of noncompliance stage in the 2023 report to Congress. And in the 2024 report to Congress, there were no plans that got to that stage, which again is a sign of the practice of the tri-agencies to try to work with plans to correct errors before you got to that final stage. As far as the effective dates, we talked about them a little bit, and they're noted here. So, for prior to the final rules, plans were required to do both the QTL analysis and the NQTL comparative analysis for plans years on and after 2025, which for most plans, and mainly calendar year plans, these requirements are in effect, that they need to do the fiduciary certification, and they need to do the NQTL comparative analysis in response to a request for by the Department of Labor or by participants. And for plan years on and after 1/1/26, plans need to comply with these requirements that are listed in this last column here. Some practical pointers to think about. One is, what does it mean for an ERISA plan to engage a qualified service provider? That is not defined, but we were not trying to create a new level of service provider. We expected at the Department of Labor that plans would be really looking to their existing service providers, whether they be third-party administrators, pharmacy benefit managers, to assist and guide through this process. But we were really just looking to fiduciaries to be thinking more about whether or not they had the support that they need, and they have the right providers there to help them with this comparative analysis, and whether they might need to engage a consultant or a separate service provider if their TPAs or their PBM was not up to the task. For ERISA plans, we do think that it's important for plan fiduciaries to be familiar with the requirements of MHPAEA, to make sure, again, that they have the right team with them to be working on doing the review and to monitor the process as it goes along. I do think that it is important for plans and for folks who are advising plans, working with plans, to be focused on the various priority issues that the Department of Labor identified, both in the final regulations and in the report to Congress that was issued in right at the beginning of this year on January 17th, right at the end of the administration. The tri-agencies issued their report to Congress. And in that report to Congress, it gives a lot of examples of what we were seeing in enforcement and what is important, and just examples of where plans were getting it right, where plans were not getting it right. We included a model settlement agreement, not a model settlement agreement, but a sample settlement agreement with a plan that showed what types of steps the plan was taking, and that were acceptable to the Department of Labor. So I know that the department was working on an updated compliance tool, was working on a model comparative analysis, and so hopefully more guidance will be coming. But in the meantime, those are some tools that the report to Congress is really a great guide to be looking at, as far as what plans can and should be doing. But some of the priority issues are issues, again, like network adequacy. There's a lot of talk about that, whether or not there are sufficient providers and how a plan can be getting to that point. nutritional counseling benefits. So we saw a lot of issues where plans had blanket exclusions for coverage for nutritional counseling for eating disorders, and did not have those same types of restrictions on nutritional counseling for other types of medical conditions, for example, for obesity or cancer patients or diabetes patients. And so that is an issue that that plans should be looking at within, their own plans. Um, Applied behavioral analysis therapy for treatment of autism. That has been an area that has there's been a lot of focus from the tri-agencies on how plans are covering that type of therapy. So that's something we included a number of examples on, and plans should be looking at. Um, the Department of Labor in the last administration was very focused on coverage for benefits for coverage of gender dysphoria. Will remains to be seen how the new administration might be approaching that type of treatment, but it was a focus of the last administration for sure. Some developments that I'd suggest that practitioners keep on top of is, again, what does the change in administration mean for mental health parity benefits and for enforcement of mental health parity? Um, Parity has and coverage of mental health care has always been a pretty bipartisan issues. The current administration has not yet said much when it comes to coverage of mental care, so it's not really clear where this might be going. But I'm hopeful that, we will continue on a path of continuing to work together between the regulators and plans in bringing about parity. Um, the reports to Congress, I again refer you to them as a helpful tool in seeing what the agencies were seeing in the enforcement context, and how they were approaching that. Great examples and tools there. Under the Supreme Court decision in Loper Bright, there are questions about whether or not there will be challenges to the proposed rules. And we haven't seen too much yet in that vein, but there may be further challenges as to the agency's authorities with respect to these rules. And there was a lawsuit that was filed by the ERISA Industry Committee, Eric, on January 17th, opposing the final rules, challenging the final rules. That lawsuit, it's unclear at this point how the new administration will be approaching that lawsuit. The most recent news that I'm aware of is that the administration requested and obtained an extension of time to respond to that lawsuit. So my thinking is that the administration is trying to uh, get more of its leadership on board so that it can make determinations as to how to approach this. So that is what I have. Let's see. So I'm just looking quickly. We have one question in the chat that states that plan sponsors do not control various areas of concern, such as network adequacy, and are there any suggestions for plan sponsors who do not control their vendors' compliance? So I do think, and this was certainly an area of concern for that was voiced many times by plan sponsors and by employers, and that I certainly saw in private practice before coming into my role at the department, that there are many things that are not necessarily within the direct control of plan sponsors and plan administrators, and they need to be relying upon the networks that they work with and the insurance companies, or the PBMs that they work with. The suggestions that I would have here are, number one, for plan sponsors to really just be sure to um, define to the vendors that they work with, to the service providers that they work with, that mental health parity is something that is very important to the plan sponsor, that they want and need this information, that they have expectations of the service providers in getting information and being able to evaluate where they stand, and also being able to see improvements in these areas, and just continuing to put pressure on the service providers in these areas, and to set expectations there. And there has been a lot of talk of various proposals from a legislative perspective to put more responsibilities on service providers as well. And so I think that to the extent to which those continue to move forward, there may be some changes here, but in the meantime, I think the biggest focus is to set expectations and to just try to be working together to to get to a better place where mental health parity is concerned. But anyway, so thank you very much for your attention, and I think I'm now turning things over to Elaine.
Well, a big thank you and a round of virtual applause to Lisa Gomez for that analysis of the new rule, the new mental health parity rules. One other thing I wanted to mention to you is that it's my understanding that today's seminar, both speakers, will be recorded and posted to our section's website with the state bar. So I'm not sure how long that'll take, but you should be able to go back and re-review this information, because that was a lot of information. And we appreciate the bar for doing that. Our second speaker, Elaine Yap, is going to talk to us about the basics of equity compensation. And so with that, I'll turn it over to Elaine.
Thank you, Doug. So hopefully you can see my screen. So as Doug said, my name is Elaine Yap. I'm an associate on the tax and benefits team at Nelson Mullins. As he said, we have an office in Atlanta, but I actually work out of the Columbia, South Carolina office. And today I am excited to be presenting on a CLE on the basics of equity compensation. So, yeah, today's presentation is basically supposed to be just an overview. So there'll be quite a few topics that we're not going to do a deep dive into. It's mostly focused on the common issues and common forms of equity compensation that you're likely to run into. So the first thing that I'm going to cover is the purpose of equity compensation. So as we all know, employees, executives, officers, and directors, they'll receive some type of base compensation, whether that's hourly rate or salary. They might receive some severance or bonuses. The purpose of equity compensation is to provide an alternative to the cash payment compensation that we normally see. So depending on how that compensation is structured, how the equity compensation is structured, it can be used to create a long-term or a short-term incentive. Companies tend to like equity compensation because it aligns the interests of the company's service providers, or in the case of an LLC, the members, to the company's interests. In theory, the service providers will work harder because if the company sees growth, then the compensation will see growth as well. So the goal of this is to improve the company service provider productivity, and then with the interest of benefiting the company shareholders. Equity compensation has kind of become an expectation to a lot of these C-suite executives. It's often something that companies evaluate their peers on to see what kinds of equity packages that they're providing, and then seeing, how theirs kind of line up against those potential competitors, and with the goal of retaining talent or adding talent to their company. The benefits of equity compensation include that it has the ability to be paid in cash. You can pay it out in shares or a combination thereof. It allows for there to be to address issues like liquidity concerns. So a company, if the recipient of this award wants cash, it would be give them opportunity to pay out in cash. And it would allow the company to retain any voting interests they have to their shareholders or the members that they have in their company. Or if the company decides to pay out in shares, that would allow the recipient to get an ownership stake in the company if that's what that recipient desires and what the company desires, and it would allow the company to keep cash on hand instead of having to pay that out. So when properly designed, these equity incentive plans can deliver tax deferred growth on the shares. It depends on whether there's an opportunity of capital gains growth, or if it will allow for deferred compensation or long-term capital gains. Just depends on the design of the structure. So when we're looking at equity incentives, I'm gonna focus on the typical structure of these equity and compensation incentives. We're not going to look into a lot of specifics, but I will flag that most of these equity compensation incentives are going to be awarded under a securities exemption, which is the main exemption that it is used to grant these awards under Section 701, which allows a company to grant equity securities without registration pursuant to an employee benefit plan. So when we award these equity incentives, we generally award these incentives under what's called an omnibus plan. These aren't your typical plan documents. They allow for flexibility so that the company can grant a variety of awards under that omnibus plan. Companies like this flexibility because, you know, for certain employees, like your officers, you're going to want to award restricted stock or incentive stock, but for a lower level or rank and file employee, you may not want to provide that same type of equity because you're not going to want to give any interest in the company. But instead, you want to provide them with stock appreciation rights, and that will get them be eventually settled and paid out in cash. So the goal is to keep these omnibus plans flexible, so that the company can provide what they want down the line without having to make, you know, adjustments at that time. When establishing these plans, there are many different things to consider. Some of the key considerations include having to determine what the vesting schedule is going to be, or when this award is going to vest. You know, you want to consider what's going to happen upon the forfeiture of these awards, what happens on termination of employment, what happens on a change of control. Are you going to vest on the change of control, cash out these employees, roll it into a buyer's plan? So when you draft these incentive plans, you're going to have to look into the future and determine what the goal is for that equity compensation. For example, if your goal of the plan is to ensure that these employees stay with the company through an exit event, then maybe you want to draft it so that the awards vest upon the change of control, as long as the employee stays with the company through the change of control and that transition over. On top of that, you want to give these administrators, so that'd be the board or a committee that is in charge of, you know, administrating these plans, as much discretion as possible so that they can tailor everything for these awards and grants. You want them to be able to tailor everything to the transaction that is at issue. Another thing you want to consider is the balance between making these plans understandable for your clients and for the employees that are going to be receiving these grants. You want it to be easy to understand and easy to administer. But at the same time, you want to make these plans flexible, contain all the necessary provisions. And you want it to get the client and the employee that will be getting the award. You want them to have everything it wants in it. So the drafting portion of it, requires a lot of forethought and consider a lot of issues at the same time. So now I want to highlight the different types of equity compensation that we see. So we have stock options. These are either incentive stock options or non-qualified stock options. Incentive stock options are generally reserved for your C-suite individuals or who have had early entrance into the business, or people who have been with the company really early on so that they can be a part of that growth. The incentive stock options are the key part of them is that, and these can only be awarded to employees. So if you have a client and they want to grant an incentive stock option to a consultant or an independent director, they can't do that. That is not compliant with section 422 of the code. So when you are drafting these awards or advising your clients, it's important to make sure that you know who the recipient is of this award, to ensure that you're going to give the correct type of stock option. So for vesting, stock options can be granted to fully vest on the day of grant. So meaning that they can be exercised immediately. But typically we see a vesting schedule of some type. So normally it's a time-based or performance-based vesting schedule. A standard vesting schedule is a 4-year vesting schedule where there's 25% that'll vest on the first year after the award is made, and then the 75% remaining will vest over the next 3-year period, whether that be annually or quarterly or something similar to that is part of the company's decision and can be established in that award agreement. Some industries and certain types of companies like startups or companies that are held in private equity also allow for early exercise. This is when you can exercise the award prior to the vesting of it. This is something that's becoming a little bit more common. And when this happens, you vest prior, or you exercise prior to vesting, and that gives them restricted stock. And essentially it'll vest where the restriction will lapse at the same schedule as the options that are underlying that agreement. With all of these equity incentive plans, you need to consider who is administrating the plan as well. Typically, it is the board, a compensation committee of that board, or an officer that is delegated by the board. So when looking at a plan, you need to know who has that authority under the plan to make these awards and to administer anything related to it. If a company decides to delegate authority to an officer under the plan, it also should note that the officer who's delegated can't make awards to him or herself. So that any awards that would go to them has to be kept with the committee or the board itself. So incentives, stock options, continued. These are the types of options that satisfy requirements of section 422. of the code, and they have a special feature of these options that allows a recipient to have compensation, to receive compensation at a capital gains rate. And then potentially long-term capital gains if the various holding periods for these incentive stock options are met. As noted earlier, only employees are eligible for incentive stock options, or ISOs, which is what they're frequently called. One thing to keep in mind when structuring these awards is that there's a time limit on the amount of time they have to exercise. So for ISOs, especially after termination of employment, there is a 3-month limit for when you can exercise after being terminated. It is often for regular options, you often see that if an employee dies or suffers some type of disabling condition, that there's a provision that would allow them to exercise within 12 months of that termination of an employee. But for ISOs, that's not allowed. You can only exercise within 3 months after termination. And, you know, sometimes companies will attempt to extend the period past 3 months with, you know, changes to the award or the agreement. And this has a number of issues because if you make any changes to the award, it will be treated as a new grant. And if it gets treated as a new grant, then the date of the new grant, it has to meet all of the ISO requirements. So that means the exercise price has to be the current fair market value. And otherwise you risk failing to meet the ISO requirements. So it's best to leave the ISO as is. And if you want to make any changes, or if there's an issue with the timing, then, you know, the best options are probably to supplement the ISO or to grant a new ISO, or just consider a different equity incentive for this individual. So ISOs must be granted pursuant to a written plan approved by the company's shareholders. So when you are drafting an equity incentive plan, the board actually adopts the plan. It sets the authorized share pool, and usually at the time of the grant, it approves the types of equity incentive awards that will be granted under the plan. They may also adopt the 409A valuation, which we will discuss later on, and then approve additional awards under that in that situation. But if the company's intent is to adopt or to issue ISOs, it's best to do a joint consent with the board and the shareholders to adopt the plan and then approve the issuance of ISOs. Because if there's no shareholder consent, then the plan cannot grant ISOs. And if the company thinks that they can grant ISOs without that shareholder consent, those ISOs are going to automatically be treated as non-qualified stock options. Another thing to be aware of with ISOs is that they must be granted within 10 years of the plan's adoption or approval by the shareholders, whichever is later. And then the ISO must be exercisable within 10 years of the date of grant. This is established by the regulations. So even if a company wants to extend past that 10 years, they cannot. A key issue that for incentive stock options, as I mentioned earlier, is the fair market, making sure that the exercise price is the fair market value of the stock options. Generally, options are always granted at fair market or above, but for ISOs, if you grant at a discounted rate, it automatically no longer qualifies as an ISO. So it would be automatically treated as a non-qualified stock option. And that could raise 409A issues, which I'll discuss later, but for ISOs, there's no wiggle room to grant a discounted exercise price. For individuals, who own more than 10% of the company. They have special rules for ISOs. So if they own more than 10% on the date of grant of the company, they have to receive the ISO at 110% of the fair market value as of the date of grant, and then they have to exercise within 5 years from that date of grant. Another consideration with ISOs is the $100,000 rule. So ISOs that are vested in any one calendar year, they cannot exceed $100,000. So when a company is at its startup phase, it would take a lot of shares probably to hit that number of 100,000 because the value of those shares are just lower. But for larger companies or mid to late stage companies that have higher value stock, the 100K value needs to be considered because it could potentially get triggered. Further, these awards compile. So if you grant awards in 2024 or if you granted awards in 2024 and you were below the cap, but then you granted awards in 2025, those combined could push over that 100K cap. That's something that also needs to be focused on. So the taxation of incentive stock options. So these are not taxed at grant. They are not taxed at vesting or on exercise. But the spread of these ISOs, so the difference between the fair market value on the date of the exercise versus the fair market value on the date of the exercise. So the fair market value on the date that it's granted versus the fair market value on the date of the exercise is a line item for A&T purposes. Absent that issue, the ISO is taxed when it is disposed of, so sold, exchanged, or transferred, or something related to a change of control. ISOs may receive long-term capital gains treatment if it has met the required holding period. So for ISOs, that'd be 2 years from the date of grant and 1 year from the date of exercise. If you instead sell or dispose of those shares before the holding period is met, it will be taxed the same as non-qualified stock options. Let's see. Non-qualified incentive stock options. So these are sometimes referred to as NQSOs or NSOs. You'll see both sometimes. These are basically options that don't qualify as an ISO under section 422. And whether that could be intentionally done where you don't want to issue an ISO or unintentionally. Non-qualified stock options can have the same terms as an ISO. So it is recommended that any option that when you're drafting the plan document, it makes it clear that the grant of an option that isn't clearly designated as an ISO is going to receive non-qualified stock treatment, or be designated as a non-qualified stock option to ensure that those stocks that meet ISO requirements but are not intended to be ISOs are treated as a non-qualified stock option. Non-qualified stock options are more flexible than ISOs. They can be granted to contractors, independent directors, employees, consultants, and sometimes entities. The exercise price for these must be no less than 100% of the fair market value to be a 409A exempt option. You can grant a discounted NSO if you meet certain requirements. Primarily, this is when the option can only be exercised upon a certain event, such as a change of control as defined by 409A or a separation of service as defined by 409A. So in a normal ISO or NSO, it can be exercised at any time before the expiration of the exercise period or within the period allowed after termination. But in these special circumstances, it will only be exercised after that required event has occurred. And if you screw up this 409A exemption, where you are granting a discounted NSO and you have to meet these 409A exemption requirements, if that gets messed up, there are penalties of a 20% excise tax of the spread for every year that that option is out there. And that's on top of any of the other ordinary or capital gains taxes that are going to be applied anyway. So for the tax consequences, these are not taxed at grant or on vesting, but it is taxed on exercise, on the ordinary income recognized on the spread. Once exercised, the capital gain holding period starts. And you do not have that 2-year holding period from the date of grant requirement that we had for ISOs. But you just have your regular holding period once that grant has vested. Let's see. Okay, so now restricted stock. Restricted stock are actual shares of the company. The employee is awarded actual shares of the company. Employees receive actual shares of stock that carry a restriction. Restriction could be you can't sell, transfer, or dispose of the stock in any way until that restriction lifts. After a specified period or after a specified event has occurred or certain conditions are met. After the conditions are met and those restrictions are lifted, that is generally referred to as vesting. A company can award the shares of restricted stock outright, or it can require the award recipient pay a purchase price for the shares. If there's a purchase price requirement, it can be set to anything, because it isn't subject to 409A. So these restricted stock options are not subject to 409A. However, it's typical that these are awarded without a purchase price payment requirement. These restricted stock options also come with voting rights, the same voting rights that other shareholders have, because it's actual stock. You're receiving actual interest in the company, so you get the same rights as anyone else that is holding stock. Restricted stock is generally not taxed. Restricted stock is generally not taxed at the time. Restricted stock is generally not taxed on grant, but instead taxed on the fair market value of the restricted stock on the day that the restriction lapses. So if the price goes up on the date of grant, then there can be a pretty, if the price goes up from the date of grant, then there can be a pretty significant tax at the time that the restriction lapses. There is a 83B election, which I'm going to discuss later, but that will allow the time of tax to shift, and will also change when the holding period starts. So the holding period for restricted stock starts when the restriction lapses. So it's either going to happen at the grant of the restricted stock if there's an 83B election, or later down the line when the restriction lapses. Next, I'm going to cover restricted stock units. These represent the right to receive an equivalent value in cash or in stock. So it's really a promise to pay cash or stock on some future date, and it's typically settled with stock, even though you can settle in cash. These are light options. They can vest according to performance metrics, or they can settle on a time-based fixed date in the future. These RSUs are the right to receive shares. But they do not provide actual shares. So they do not carry voting or dividend rights. However, an RSU award can be structured to provide dividend equivalents. This would provide an RSU recipient with a dividend at the same time and at the same amount as the dividend paid to a shareholder. These dividend equivalents are subject to 409A. So the award agreement needs to be very specific on the time and the form of the payment as to not run into these 409A issues. RSUs are not taxed at grant because it is just a promise to award stock or cash in the future. RSUs are taxed at the settlement of the award, so not necessarily at vesting, but when the settlement occurs. However, vesting and settlement tend to be at the same time, but are not always. If you are receiving stock, you'll pay ordinary income at the fair market value at the time the award is settled. And if it's cash, then you would pay ordinary income on the settlement of the amount in cash. Stock appreciation rights. The holder stock appreciation right is where the holder gets a right to receive the excess of the fair market value of an underlying share of stock over the exercise price of the stock appreciation right, or SAR. So these are very similar stock options, but there's no actual purchase of shares. SARs is what they're commonly referred to. These are exempt from 409A if the base price or the exercise price is at fair market value on the date of the grant. So for example, later down the line, the recipient decides to exercise the SAR because the share price has gone up significantly. The company can settle the SAR in cash, shares, or a combination of the two. Settling in cash or shares depends on a couple of considerations. If there's liquidity issues, the company doesn't have cash on hand, then it can settle the SAR with stock. If the employee doesn't have cash to pay the taxes, then the company can settle with a combination of stock and cash. So the company would settle a portion of it in stock and then provide the employee with cash so that the employee can meet any of the tax consequences related to this settlement of the SAR. And then these are taxed on exercise, and it is always taxed at ordinary income on either the fair market value of the shares received or the cash amount that is paid out on the settlement. Other forms of stock incentives. So we have phantom equity. This is a promise to pay cash on a hypothetical amount of shares, essentially just a promise to pay cash based on the value of the company's stock. This is commonly used for LLCs because an LLC, when they grant an equity incentive award, that unit holder will receive a membership interest. They will become a K1 employee with voting rights instead of just a regular W-2 employee. So phantom equity allows LLCs to avoid that issue while still being able to award equity compensation to their employees. So for example, they could give out a cash bonus through a phantom equity to their W-2 employees. And that would be paid out based on the appreciation of the LLC units or based on the fair market value of the LLC on some fixed date. The last two that I'm going to cover is performance shares and performance units. These are not that common, but still something that you might see. So a performance share is generally an issuance or award of shares to a participant based on some specific performance metric. A performance unit is conceptually the same thing, but instead it follows the rules of stock units, meaning it has a fixed value that if or when vested, can be paid out in shares, cash, or a combination of the same. So I think that is those are the main incentives that I wanted to cover. Now I'm going to jump into the 83B election. This is an election that allows the recipient to recognize income prior to the vesting of the restricted stock. So as I had mentioned earlier, restricted stock is normally taxed at the time that that restriction vests or that restriction lapses. So if there is a lot of growth in value from the time of the grant to the time that the restriction lapses, there's going to be a pretty significant tax burden at that time for the recipient. An 83B election allows the recipient to elect to be taxed at the time of grant, at the fair market value of the time of grant. So this is a popular option for companies that are startups, or generally any company that is expecting significant amount of growth. A lot of startups like this because the value of their shares or their stock at the time that they are getting started is going to be very low. So the 83B election will allow them to have a low fair market value at the time of grant, which means lower tax implications. So to make this election, it has to be made 30 days within 30 days of the date of grant. There's no exceptions. While there's some workarounds that can be used, it will never put that employee in the same position as if there was a valid 83B election made within that 30-day period. There's a potential downside on an 83B election. So because there's no ability to revoke this election. So if there's a drop in value and the tax implications would have been way lower if they had gotten taxed when, later in time, if there was a drop in value, they can't go back and claim a refund in the amount of for the value that they paid more for versus what it is now. So an 83B election really would make sense only if the employee thinks that the stock price is going to go up in the future. Also, when you make the 83B election, it starts the clock for capital gains holding periods. So that increases the opportunity for long-term capital gains treatment because that timer is starting way earlier on than waiting for all of those restrictions to lapse. And also, we want to note that the decision to make this 83B election isn't up to us or really the company, it's up to the recipient. So obviously we'll want to advise the company on what the implications are for them and their employee, but the main decision is going to be made by the recipient with his or her advisors, determining whether that 83B election would make sense for them when receiving a restricted stock. 83B elections are not available for all types of equity. It is allowed for restricted stock. It could be allowed for non-qualified stock options. So normally it's not permitted, but if it's one of those special situations where we have early exercise, then an 83B election could be allowed. However, that really complicates the award itself. So that's going to take specialized review by someone who focuses on executive compensation. So it's not something that should just be, drafted up and approved without further review. And then for ISOs, RSUs, and SARs, there can't be an 83B election. It's never allowed for ISOs, and then for RSUs and SARs, you can't make an 83B election because 83B only applies to property, and here there's no property. It's just a mere promise to pay with either shares or with cash sometime in the future. Now I'm gonna cover code section 409A. This governs all deferred compensation and, can be a pretty expensive section to mess up. So, it's important to be able to flag that this could be an issue. If you see something that, we're gonna talk about arise. So 409A governs all deferred compensation. Deferred compensation is a legally binding right to payment of compensation where the right to that compensation is promised in 1 year, and then the payment of that compensation is going to be paid some later calendar year in the future. So that's the basic definition of deferred compensation. Some executive incentives are exempt from 409A. Typically, that's going to be your non-qualified stock options or your RSUs. Your restricted stock or your ISOs. ISOs, by their terms, are exempt from 409A. Some executive incentives may be subject to 409A on the date of grant, or they can become subject to 409A in the future, based on the fact that you have amended awards or something. So for a stock option to be exempt from 409A, it must have an exercise price of no less than 100% of the fair market value on the date of the grant. It must be issued with respect to service recipient stock. So essentially that means that it's the stock of the company that the individual is working for. And there must be no deferral feature in the terms. There are special defined terms for 409A, so disability, good reason. Disability, good reason, change in control, fair market value, and separation from service are some of the, common ones. If there is a plan or agreement where the company wants a payout upon one of these events, it's important to make sure that that event meets 409A definition requirements. Another important feature for 409A is that it must have a 409A valuation when granting this equity compensation incentive. It's important for multiple reasons. One, in order to have exempt options, you need a 409A valuation set for the exercise price. But it is also important for restricted stock. So restricted stock is exempt from 409A. But if you make that 83B election, you have to pay the fair market value of the restricted stock on the date of the grant. And how do you establish the fair market value? Well, the 409A valuation is what can be used and is what is generally used to establish the fair market value and establish the correct amount of tax that the individual would be liable for. There are also various rules for 409A for modifying, extending, or substituting, or for assumptions. These have very specific rules under 409A. If a company is want to make any of these changes, that is something that's going to need a specialized review by someone that does this type of employee executive compensation, because you want to make sure that their changes don't run afoul of 409A. If there's a 409A failure, that is going to lead to some significant penalties. There will be a 20% excise tax, interest on any of the late payments, and then that's all on top of the other tax implications that are already there. In addition, these penalties are always going to be on the employee. And it's not going to be on the company. Typically, so you don't have upset employees, especially because if there's a 409A failure, it's common that the company was at fault for this 409 failure. The company will generally gross up the employee to pay the penalty. But it's best to just avoid 409A failures because it can be an expensive mix up or failure. Next section is 280G. So this is generally focuses on parachute payments. 280G governs parachute payments when there is a change in control or event. So it doesn't apply to everybody. There are certain individuals that need to be have a 280G analysis done. If they have significant payments that are going to be made up to them on a change of event or change in control. So it generally applies to certain officers, certain shareholders, and then highly compensated employees of the company. 280G looks at the amount of the payment to those individuals as a result of the change in control. And if that amount as calculated is above a certain amount that's established under 280G, then there's going to be an excise tax equal to 20% on the excess parachute payments that exceed a certain amount as, calculated under 280G. There are ways to cure or avoid a 280G issue. So for a private company, you would be able to do a shareholder cleansing vote. For any company, you could do a cutback on these change of control payments. Or you could try to increase the free change of control payments. If that is a possibility and you're where they're at in the transaction, then sometimes you have some wiggle room there. But really the key takeaway for this presentation is that if there's an equity incentive awards and there's any accelerated vesting, a 280G analysis may be needed and should be flagged prior to the closing of that transaction. 280G calculations require special attention if there's accelerated vesting in connection with a change of control, because then you'll have to allocate and calculate the additional payments that will result from the lapse of restricted vesting or the early vesting of any of these equity incentives. Plans will generally have terms in them on how these are going to be treated at a change of control. If there's, specific situations where the payment won't have to happen, when it will have to happen, what's going to happen if there's an actual termination, what happens if the termination is based on good reason, death, etc. But it is important to look at the individual award because the award might differ from the plan or have specific terms that may make the analysis a little bit different for each individual. And if there's a contrary employment agreement provision that somehow interacts with these awards or they intersect in some way, the award document and that plan document for these equity incentives, they're going to control and not the employment agreement. So when you're drafting these awards, it is important to evaluate the employment agreement and either, make everything line up with what is expected based on the employment agreement or make those adjustments at that time, at that drafting time. And then the last section that I wanted to cover today is that, and this is more related to companies. For public companies, Section 162M imposes a limit on the deductibility of compensation paid by a publicly held corporation or companies that have publicly traded equity or debt to certain high-ranking employees referred to as covered employees. Specifically, the section limits the deduction on compensation paid to covered employees to $1 million per year before the TCJA. Certain performance-based compensation could be excluded from that 1 million deduction limit. But the but the Tax Cuts and Jobs Act removed that exemption. So unless there is a binding contract that was in effect on November 2nd, 2017, and has not been materially modified after that date, there's not an exception for performance-based compensation from that $1 million deduction cap. The TCJA also added a feature that is called the once covered, always covered feature. So let's say in 1 year, you have somebody, so the covered employees generally are your CEO, CFO, and then your 3 highest compensated employees. So let's say in 1 year, someone is a covered employee because he or she is the highest compensated officer of the corporation. But in the next year, let's say in 2025 now, they're no longer one of the top 3 highest compensated employees. They are still going to be considered a covered employee going forward. So you'll have the new individual that got into the highest compensated list, and then that other individual that just got kicked off the list will still be considered a covered employee. And that list will just continue to grow going forward. So that covers the basics of equity compensation that I wanted to cover in this presentation. Let's see if there's any questions. Chat. I think I have anything. I guess I can also cover a few of the general trends that we are seeing. Right now, we've seen some pretty large cases that have occurred recently and that are still going on right now, actually, where there are awards that are being granted to certain individuals that are receiving pretty significant scrutiny. You know, before these awards could sometimes be, you know, provided to retain top leadership, and it wouldn't, you know, draw a lot of reaction. But now we're seeing a lot of criticism and scrutiny on on really large equity incentive plans and benefits that are provided. So it's something that going forward, companies should probably, you know, make sure that all of these equity incentive plans are, you know, really backed up by numbers, by performance, and, you know, well documented to support the decision-making process behind providing large equity incentive plans and awards. A separate issue that is probably going to continue to be coming up is that with the change in the market structure right now, we're seeing companies not wanting to wanting to save more cash. So potentially stock focused equity plans might be more commonly used going forward. There's also a desire to retain top talent for longer periods of time. I'm more concerned with people moving between companies. So longer vesting periods or longer agreement periods are something that are also trending upwards to try to address some of the volatility in the economy right now. So I think that covers it for me. I don't know if Doug, you have any closing remarks you wanted to do at the end of this training?
No, I'd want to thank you Elaine for that presentation and another virtual round of applause. Thank you very much. That concludes the seminar. I'm sorry we're running a little bit late to start, but it looks like we got out on time. So appreciate everyone being here. And again, if you want to take a look at the presentation again, it should be posted to the sections portion of the bar website.
Ladies and gentlemen, this does conclude today's meeting. Thank you for joining. Have a great afternoon.